and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. It seems so long since we last met.
We don't ever go too long without speaking to each other.
No.
But we were just commenting on the lovely sunny day, so that's good. We're in a good mood. It's a Monday. We're going to be talking about a new county court decision today from the 14th of March. The case is called Spirit Pub Company Managed London and Pridewell Property Ltd. And it's all about the Landlord and Tenant Act 1954 and Ground F in particular, which is demolishing and reconstructing. And I think it's going to bring in lots of different issues, this one. So should we start with the background facts?
Yeah, well, it's a pub, as you may imagine. Ground F's obviously an old favourite, which we've discussed over the years, probably the most litigated ground for proposing a new lease there is under a 54 protected lease. It was a pub called the Railway Bell, which seems to have been around for many a year. There were title deeds from 1870 in sort of reference when it went through first registration to restrictive covenants, and as so often the case, no details were provided on first registration. So we don't really know if they were being breached or not. But what happened is that it was in 1995, in April of 1995, the current lease, 54-hour protected lease, had been granted to terminate in June 2024. And the Spirit Pub Company had taken on an assignment of the lease in October 2007. Pridewell was a special purpose vehicle who took on the conversion in 2014. Intending, when the lease came to an end, to convert it to the premises to mixed business residential. It was currently, as we know, a pub, but there were residential elements up above. I think they seem to have been used for employees of the pub. And in July of 2023, less than a year before the lease is due to come to an end, the tenants served a Section 26 request. They obviously realised what was going on and wanted to push things along so the landlord wouldn't be ready by the time you go to court. You have to have a clear intention, and we'll perhaps talk about it later, it's Betty's Cafe and Phillips Furnishing Stores, a House of Lords case we've dealt with over the years from 1959. You have to have a clear intention by the time of any court hearing. So the tenants pushing the landlord along, and there were several arguments that were put forward by both parties, which I shall tell you if you like.
Yes, please.
Well, the first one, quite an interesting one, actually. We've never discussed before a few weeks ago when we talked about something similar in another podcast we did. You have to have that intention. Well, the courts have decided. Well, the legislation says that after the lease comes to an end, what happens is it'll come to an end finally. Some months. No, if it says less than 3 months, then it's at least 3 months after any court hearing. Section 64 of the Act applies. So the lease will continue after court hearing, court decision, for 3 months in this case. And then the courts have interpreted you've got a reasonable amount of time, which obviously depends on the facts, to then commence the work. And the landlord, it was found that they would be able to commence the work for various reasons, but not before 14 months had passed, which is a long, long time. Some of the older cases, there was a case called Livestock Underwriting Agency in Corbett and Newsom, one of the earliest cases on the 54 Act from 1955, which basically said you've got your 3 months after the date of the decision, and then you've got sort of 3 months and 21 days. There's a case called Court of Appeal case called Edwards and Thompson from 1990 that said on the facts that you can have a matter of months and even longer. I don't think anybody would question 3 months. And another case more recently, although it's a county court case, London Kendall Street number 3, and Asian Investments had said 6 months and 21 days as a rule of thumb. It's been very precise, that. And do you remember a case we did? Well, it was only in February. It's MVL Properties and the Lead Mill. Do you remember that one? The music centre, Lizzie.
Yes, I do. Yeah.
Which was in Sheffield, you remember? Who I mentioned in a course last week. I mentioned to everybody that it's where pulp started off in life. Do you know pulp?
Mm-hmm.
People had never heard of pulp, which I find amazing, and Jarvis Cocker and Britpop, and didn't know what I was talking about. But anyway,
your references are dating you now, Richard.
Well, that's quite old. I was quite old by that time. It's me. I'm more kind of Bill Haley and whatever he had in the Comets. Bud Holly and the Crickets. But anyway, that was about using ground G. But they sort of similar kind of thing. The landlords wanted to run their own music centre, but the tenant could strip out the premises at the end of the lease, so he wouldn't be ready for about 6 months. And they said that that's a reasonable amount of time. And in any case, the fact that you'd be going into possession of the premises almost immediately to start fitting out and likes, that was part of the occupation. But on the facts, in this particular case, the county court decided that 14 months was reasonable. Not least of which because the tenant had declined to give the landlord voluntary rights of access, so he could do preparatory work, dig trial holes and likes as preparatory for putting in planning applications for the change. I didn't understand that part. The court decided that basically the tenant had every right to object to this. But in any case, they decided that that gave the landlord a longer time period. So 14 months on the facts, and very much on the facts, was still reasonable. So that was one reason. Shall I mention others? There were several.
Yes, please.
The tenants tried to argue. There's another case that we've mentioned over the years, a Supreme Court case from late 2018, S. Francis and Cavendish Hotel, which was the first case that really settled there's a but-for test that, would you still want to do work on the premises if the tenant had vacated of their own accord? So the landlord was strangely putting in a step in a basement that he claimed wanted to do for no apparent reason, and replacing a wall. I remember a dividing wall with another dividing wall looking exactly the same with the same materials in the same place. And the Supreme Court said there's this but-for test. You've got to show that, but for the amount of work, but for the fact that the tenant's still in possession, you would still want to do the work. And the tenants tried to argue that the same must apply to there's a sort of but-for test for the timing of the work, if you like. The landlord wanted to start the work before he put in his planning application, basically because the tenant had pushed him into it. The tenant's going to speed things up, and the landlord presumably wouldn't be ready with ground F. But the court said that the timing of the works and the time of the commencement had nothing to do with S. Francis. The but-for test will not apply. There was another one. There's another one that the landlord actually succeeded on, if you'd like to know.
Yes, please.
Yes, I can see you're excited by it. It's basically if you've got the right to do, enter the premises and carry out the works anyway. I mean, ground F basically says that the landlord intends to demolish or reconstruct the premises, comprised in the holding or a substantial part of the premises, or to carry out substantial works of construction on the holding or part thereof, and that they could not reasonably do so without obtaining possession of the holding. So there's cases I haven't really mentioned in the courses we've done, but there's a House of Lords case called Heath and Drowned from 1973, which basically said if you've got the right in the lease to go into occupation and do the work yourself anyway, then you can't use ground F. And there have been several cases on that over the years. There was a case called Price and Esso, a Court of Appeal case from 1980, where the leases contain provisions allowing you to enter, the landlord to enter, to carry out improvements, additions or alterations. And the court decided that therefore you couldn't use ground F. The work you needed to be done was allowed in the lease anyway. There's another one, Leith Woods and Total Oil, another petrol station car dealership, where the amounts of work were so severe, it was found that the landlord would be in breach of quiet enjoyment if he went to occupy. In this particular case, the court decided that the landlords under the lease couldn't do the work that was intended without breaching quiet enjoyment of the tenant and derogation from grant. 65% of the beer garden would be lost through the works and so on. So that didn't succeed. The landlord won on all those. But there was one final one.
Please do tell us about it.
I'll leave you in suspense, shall I? It's, well, again, we've discussed it over the years. There's really together with the but-for test nowadays, there's a two-stage process to ground F and also ground G in demolishing and reconstructing. First, it's subjective. You've got to have a fixed and settled intention. And the words of Cunliffe and Goodman from 1951, one of my favourites, out of the zone of contemplation and into the valley of decision. And subjectively, you intend to do the work, but objectively, you have to have a real chance and a real or a real prospect of bringing about, that possibility. And that's objective, as I say. And they basically decided that you might be able to get your planning permission, bearing in mind they'd started the work without the planning application going in. And it was highly unlikely they'd be able to get funding. Funding is, you have to prove that you can get funding, or a real chance, I should say, of funding. And it was highly unlikely because people are not going to take the risk of funding you before you've put in your planning applications. And the landlord admitted that the reason he'd sort of sped along, you would have done things at a more leisurely pace if it wasn't for the tenant's Section 26 request, which he had to oppose on ground F. So at the end of the day, all you need is one legitimate reason to stop the landlord under ground F, and it doesn't matter how many ones you fail in. The tenants succeeded. They'll still have the railway bell in South Woodford and Redbridge, London Borough Council, it looks like anyway.
Well, thank you very much, Richard. Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.